now come to order. Welcome to the March 14th, 2022 meeting of the City of Raleigh Board of Adjustment. My name is Rodney Swink and I'm chair of the board. I'm joined by fellow board members Kathy Rudisell, Steve Kinney, and Marvin Butler. The Board of Adjustment is a quasi-judicial body that is governed by the North Carolina General Statutes and the city's Unified Development Ordinance. We are authorized to hear requests for variances from the city's UDO, special use permits, and other requests as may be provided in the city's ordinances. In hearing cases, the board conducts a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decisions. The standard the applicant must meet to be granted their request is set forth in the UDO. The board hears and considers evidence presented at the hearing and applies this standard when making its decision. The board must base its decisions upon competent, material, and substantial evidence presented at the hearing. If you will be speaking as a witness, please focus on the facts and standards, not personal preference or opinion. Witnesses may testify as to facts to which they are competent to testify, so long as those facts relate to the legal standards. In addition, lay or non-expert witness testimony is limited to facts, not opinions. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts on traffic safety. Focusing your testimony and arguments on the applicable facts and standards will allow the board to hear cases in an efficient and timely manner. Since today's meeting will be conducted remotely, in addition to the general quasi-judicial rules, today's hearings will be conducted in accordance with state statutes that allow for remote evidentiary hearings during the current COVID-19 states of emergency. For the convenience of those participating today, I'm going to outline how we will conduct today's remote evidentiary hearings. First, all witnesses must be sworn in. Because of the remote format, individuals who sign up to speak, as well as city staff participants, have already signed a written oath form, which will be reaffirmed on the record as they testify today. Participants have also already provided written consent to today's remote meeting. We will begin with a staff presentation from a member of the planning department. Following staff's presentation, the applicant will be acknowledged to present their case and witnesses. The Board of Adjustment will acknowledge the attorney or applicant for each case first as the point person for the applicant. Following the applicant, anyone else who signed up to participate in support or opposition to the request will be given the opportunity to speak. The applicant will be given the opportunity for cross-examination, as well as a rebuttal and a closing statement. When all testimony is complete, we will close the evidentiary hearing. The board members will deliberate and vote on the case. For variance request, a 4/5 vote of the board is required to grant a variance. Let me note that today we only have 4 voting members. I will point that out again as we go, but 4/5 vote is required to grant the variance. For all the other hearings and matters, the decision will be made by a simple majority vote of the board. Following the meeting, the board's decision will be prepared with the written findings of fact and conclusions of law. The decision will be incorporated into the meeting minutes, will be adopted at the same time the meeting minutes are adopted. We will now conduct the evidentiary hearings on today's agenda. We'll begin first with an item of information, old business evidentiary hearing 1. This was 11009 Ingleside Place, Westchester commercial property owner, variance BOA 0010-2021. That case has been withdrawn. We will not be hearing that today. So we'll move to the second item of old business, evidentiary hearing 2. This is 1333, 1335, 1337, 1339, 1341, and 1343 Cortland Drive. 1335 Cortland LLC is the property owner. This is a variance, Board of Adjustment 0083-2021. For the applicant, let me remind you again, we only have 4 voting members today. 4/5 affirmative vote is required. If there is any concern on the applicant's part to hold this case until we have more members present, I'll give you the opportunity now to make a statement to that effect. Otherwise, we'll move along.
Thank you, Chairman.
Yes.
This is Mike. Oh, yes.
Go ahead.
Great. Thank you, Chairman Swing. This is Michael Birch, Longleaf Law Partners, on behalf of the applicant. And yes, we would ask for a deferral to next month's meeting because of the 4 voting members.
Okay, we want to give you that opportunity, and that's certainly your prerogative. So we will hold this case until our next meeting, which is in April, and we'll hopefully have a full contingent at that time.
Thank you, sir.
Yes, sir.
Mr. Swank, can we state the date certain just for clarity? I believe it's April 11. Is that right, Keegan or Justin?
It is April 11th. I wrote it down, but it was in the back page of my paper. But thank you, Ms. Hill.
Good.
Yes, April 11th will be our next hearing for that case. Okay. Now let's move to new business. This is evidentiary hearing 1. This is 311 Bickett Boulevard, Charles Simonson Jr. and Mary Simonson property owners. This is a variance, BOA 001-2022. Again, before we proceed, Mr. Simonson, I believe you're representing yourself. I want to give you the opportunity. We need a 4/5 vote. We only have 4 voting members today. If you're comfortable proceeding, we will do so. If you wish to defer, we will do so.
Do we have to defer right now, or can we understand?
We can go ahead through and present the case, and based on the questions that you get, if it raises concerns on your part, you can withdraw today and ask that it be held for further for a later date.
Okay, I'm fine with that procedure if that's okay with the council.
Okay, well, very good. Well, thank you. Then let's start with our staff. Travis Crane, I need to swear you in. Please reaffirm your oath. Do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do, thank you.
Yes, sir. Go right ahead.
Chairman Swink, this is Justin Booker. I am the staff member who will be presenting this.
I apologize. I misunderstood. I thought you weren't going to be here. I apologize.
Oh, no, that was Justin Remetta is absent.
Justin Remetta. Yeah,
Okay.
sorry, that's
No,
my
no,
fault.
No, it's my fault. I'm not where I need to be, and I'm a little easily confused anyway. In that case, Mr. Booker, let me reaffirm your oath, unless I just did so. Do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do. Thank you.
Oh, yes, sir. No, thank you. Go right ahead.
Okay. So this is case BOA 0001-2022, 311 Bickett Boulevard. Charles Simonson Jr. and Mary Simonson property owners are requesting a variance for 0.8 feet from Unified Development Ordinance Section 1.5.4.D.2.A, which requires mechanical equipment associated with residential uses be placed no closer than 3 feet from the vertical plane of any lot line in order to permit 2 existing HVAC units within 2.2 feet of the side property line. This is on a 0.13 acre property zoned R10 and located in the 5 Points East, the core neighborhood conservation overlay district. Shown here is just an aerial of the property. And located in green, very small, are the location of the HVAC units. The box in red is what we will take a look at in this slide. So as you can see here, there's the house, 2 AC units, and these AC units are existing. And with that, I believe I'll hand it over to the applicant for the rest of their presentation.
Okay, thank you. Board members, do you have any questions for Mr. Booker? Okay, let's move along then. Charles Simonson, you're the property owner. It's your opportunity now to present evidence and legal arguments in support of this case. If you have any witnesses, I will need to swear them in once you've introduced them, but please go ahead and present your case.
Thank you, Chairman.
Sorry to interrupt real quick. Mr. Swank, can we swear in?
Oh, of course.
Yes.
I'm sorry. I'm in a 2-hour different time zone and my mind has not kicked in yet. I do apologize. By the end of the meeting, I promise I'll be operating on all cylinders. I think it's Mr. Crane's presence that has me so nervous because I always want to do well for him. Okay, Mr. Simonson, do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you very much. Now, you may proceed. If you please state your address and your relationship to the case, although I've acknowledged you're the property owner, but just please state your address for the record.
I am, it's 311 Bickett Boulevard, 27608 and 5 Points, Raleigh. I am the homeowner. My wife is on the meeting as well. And if you may want to swear in Kelsey Doherty, she is my neighbor, who is the one probably most affected by the location of these units, in addition to myself. I will ask for her testimony at the end. If
Okay.
that's
Okay.
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 Thank you. Justin, thank you for the presentation. Would you please forward the slide? Thank you. What I present here is a zoomed in sort of topical survey of where the units are placed. This is to scale. So it's behind some foliage in the front yard, which is pretty well laid out. We'll show that in pictures forwarding. You can go to the next slide, please, Justin. Here is a view from the sidewalk. As you can see, behind the area of to the right of the house in this picture, there is a number of landscaping treatments that we've put to the house since we've moved in 2015. And it pretty much obscures the view. This was taken just a few days ago. So this is a relatively recent photo. In the winter, you can imagine during the summer and spring, it's much more full. Next slide, please, Justin. A sort of zoomed in view of it. And this one is a little bit closer, but the units are, again, this is trying to get the best view from our property. My neighbor typically parks her car in the driveway. So from the street point of view, it's a very difficult angle to actually have to see the units. So I think from a pleasantry sort of aspect of the neighborhood, it has very little effect regarding that. Next photo, please, or next slide. So I had these units actually installed in 2018 and took a long time to get many different permits. The process essentially was having the units behind my house. They were quite noisy because they were older units and they were affecting my newborn daughter's sleep at the time. They needed to be replaced anyway. When we got them replaced, I asked the contractor or the HVAC company to please, if they could be moved to the side of the home. Was given no indication that would be an issue. They swore up and down that they've done this many, many times without problem. So that was conducted in the fall, I think November of 2018. We went through the proper mechanical permits, got those approved. And then roughly about, if I remember correctly, April or so of 2019, started down the path of this the zoning issue, and went back and forth with the city numerous times to get everything resolved, and finally got clearance or got the what's the word I'm looking for here? I got the approval from the city inspector who was looking at the property and into this case at the time, as indicated in this text messaging. Here that we were going back and forth with, also extended email chain, but this was where he said he had closed the issue out. There would be no further issues. I thought everything was good to go until back in early 2021. So I believe it was maybe March of 2021, almost a year ago now. Knock on the door, a new inspector asking about the permit and the zoning issue, and that things were not closed as was indicated and as was previously paid for. Next slide, please, Justin. That's just the receipt of the permit for the zoning that I paid for on December 30th, 2019. Next slide, please, Justin. And this is the electrical permit that was conducted. I was also told that the electrical permit was not granted, although I have a receipt of it, and the HVAC company has receipt of it as well. So again, this was all around the time when the city was adjusting their systems. So I'm not sure if something got lost in the electrical database of things, but that might be the case. The next slide, please, Justin. Mechanical permit as well. And I believe I have one more slide. And it's a testimony from my neighbor. Again, the property between us, this is the units reside between my property and hers. And she has had no issue with the location of them. I'll let her speak to that if she wishes, or if it would be helpful.
Okay, is that it for you until we go to other people?
Yes, sir.
Board members, do you have
Thank
any
you for your time.
questions? Yes, sir. Any questions for Mr. Simonson?
This is Steve. Can you have a question, Mr. Simon? I just want to make sure. So you actually pulled permits for this, is that right?
Yes, sir. That's correct. We pulled all the appropriate permits. Everything should have been granted and cleared up by the end of 2019, very early 2020, as I understood it. So I don't know exactly where the permits got lost, so to speak.
Okay, thanks.
Okay.
Just as a follow-up, Mr. Simonson, you said that you got approval, but then you said another inspector said it was declined and it wasn't completed. Is that correct? And was
No,
there,
sir. No, sorry for any confusion there.
was there any
So-
explanation for the change from the city?
As I understand it, Mr. Butler, there was just a matter of not being closed out. Everything was approved. Everything was, given the all good. It's the reason why I didn't hear about this for 14 or 16 months, I'm presuming. And so, literally it was quite a large shock that last spring when I got the knock on the door from the city saying this was not closed out or ever really. I even got some indication that the mechanical and electrical permits weren't properly submitted. However, the HVAC company, Raleigh Heating and Air is the HVAC company. They have gone back and confirmed that the permits they were granted and they should have been filed, with the city correctly. As I mentioned earlier, this was the time when I know the city changed over its digital, permit system. And this was one of the reasons that caused the delay to later 2019 of being able to get things filed, because I remember October of 2019 when I was beginning to try and pay for the new zoning permit that was David Reyes told me would be required, and numerous issues of logging on and getting the appropriate permits associated with the billing account to pay for. But once it was done, he indicated to me directly that things were closed out and ready to go.
So having said that, do you have any complaints or issues, concerns from your neighbor, as you mentioned earlier?
Kelsey Dockery, would you?
Hi, it's Kelsey Dockery.
Just one moment, please. One moment before we get to her, since she signed in to speak in support. Are there other questions, Mr. Butler or Mr. Kenny?
Yes, sir. That's perfect. Thank you, Mr. Sorry about that.
Okay.
Thank you, Mr. Butler.
Okay, now, Ms. Doherty, please state your address and your relationship to the case, and then allow me to reaffirm your oath.
Sure. Hi, this is Kelsey Dockery. I live at 313 Bickett Boulevard. I am the unit or the house in the lot to the right in the pictures that Charlie has shown.
Okay, do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Now, please go right ahead.
As my letter here states, I have no problems with the location of their AC units.
Okay, very good. Questions for Ms. Doherty, anyone? Okay, we also had Stephen Doherty initially signed up. I assume that he is not online, will not be speaking.
That's correct. That's my husband. He has a work call, so I am the one representing our house.
Okay. Well, we had no one else signed up to speak in support and no one signed up to speak in opposition. So we can give the board another chance to ask any questions.
Mr. Swank, can we just confirm also with the property owner that Matthew Willoughby was with him? I know I probably put in your notes that they were together. I just want to confirm that though, since his name wasn't mentioned.
Yeah.
I'm sorry, Mr. Sweet, go ahead.
I was just going to say, I had his name down, but his name had not come up in your presentation. So I was assuming, I apologize that he was not with you. Matthew Willoughby?
I think he's on. He is my contractor slash good friend.
Okay.
He's just around here for support, yeah, if necessary.
Okay. Well, it was really up to you to whether you want to introduce him as a witness or not. So it's not required, but he was listed so that we just wanted to not overlook anything.
I appreciate that. Thank you. I don't think there's anything.
Okay. Okay. Well, with that, Mr. Simonson, anything else on your end that you would want to say for us?
Nothing additional. I just hope that we can solve this matter to everyone's liking. This has been a long time coming, and I feel like this should have been resolved and closed out at least 2 years ago. I've done everything I possibly could as a homeowner to ensure this was resolved in a manner that is appropriate for everyone. So hopefully you take that into account, please.
Yes. Okay. Well, thank you. Board members, last chance for questions. Okay, then let's close the evidentiary hearing and move to our deliberations and a motion.
I'll move to approve.
Mr. Butler, thank you. We have a motion to approve. May I have a second?
I'll second. This is Steve Kenny.
Mr. Kenny, thank you. A motion to approve in a second. Any further discussion? Then at this point, we move to a roll call vote.
Mr. Swink,
Approve?
Mr. Butler,
Approve.
Mr. Kenny,
Approve.
and I'm very sorry, is it Mr. Rudisill or,
Yes.
okay,
That's
Mr. Rudisill? Approve. You had 4 yeses.
Okay, thank you very much. Thank you, Mr. Simonson. Apologize for the delay this morning and also for appreciate your patience throughout this whole process. And we'll let you go now.
Not an issue, Mr. Chairman. Thank you, council. Appreciate your time.
Our pleasure. Okay, now let us move to our second item of new business. This is 115 Hudson Street. Cameron Scott Bowe and Mary Catherine Thompson Bowe, property owners. It's a variance, Board of Adjustment 0002-2022. And for the benefit of the applicants representing themselves, I again want to state that a variance requires a 4/5 vote of approval. We only have 4 voters today. If you're comfortable proceeding with your case, you may do so. If you have any concerns about the number, then you may ask for us to hold this for a subsequent meeting. So, Mr. or Ms. Bowe, your thoughts? Cameron Bowe, are you with us?
Hi, this is Katie Bowe. Cameron was going to speak, but I don't know if he's been unmuted.
Okay, well,
His mic was working earlier.
Okay, are you okay continuing or do you want to hold it to a subsequent meeting?
So, Mr. Swink, I have a question. Is it common that there are 4 members available for voting at meetings? I'm curious if we might face the same situation again in April.
Well, first of all, we require 4 to have a quorum. We have 8 full members. 2 are stand-ins as needed, both of whom are standing in today. This is an unusual case. We typically have 7 or 8. It's just a coincidence that today 4 have conflicts. So we can't guarantee any time. We guarantee we will not meet without a quorum. but we cannot guarantee that there will be 6, 7, or 8 people, but there usually are. If that helps.
Okay, thanks for the clarity. And if we present today and there are a number of questions, can we come back at the next meeting with more clarification before a vote if we defer the vote until the next meeting?
When we get to the close of the hearing, and if there is a sense by the questions being raised that maybe additional time might be needed on your part, then we will give you the option of asking that you hold the decision and revisit that. Is that correct, Ms. Hill? Am I stating that correctly?
Yeah, that's if the applicant would like to request a continuance at any time, especially since we're remote and operating under remote QJ COVID law that requires applicants' consent to proceed remotely. If the applicant would like to continue, they have the right to ask for that. And that continuance will be granted since you're remote.
Okay. And that could come after we've had our discussion. Is that correct?
Yeah, that's
Before a motion. Okay. Okay. Does that help, Ms. Bo?
It does, and Cameron is planning to speak on our behalf. Cameron,
Okay, so
it may need that be that the host needs to unmute Cameron. It may be on lock.
I'm unmuted now. I think we'd like to proceed for now.
Okay, great. Well, thank you. I appreciate clearing that up. And again, Mr. Booker, I believe you're going to be presenting this case.
Yes, that is correct.
Thank you.
All right. So this is case BOA 002 2022 115 Hudson Street. Cameron Scott Bowe and Mary Catherine Thompson Bowe, property owners, are requesting a variance for complete relief from Unified Development Ordinance Section 2.2.7F, which requires driveways and parking spaces to be located a minimum of 2.5 feet from the side and rear lot line in order to construct a driveway that supports a detached house and a proposed accessory structure on a 0.26 acre property zoned R10 and is located in the 5 Points East, the core neighborhood conservation overlay district. Here is an aerial of the property. And shown here in blue is the proposed driveway. Pretty straightforward. With that, the remaining pictures are the applicant's presentation. I'm happy to answer any questions the board may have.
Okay, thank you. Board members, any questions for Mr. Booker? Okay, hearing none, let's now move to the applicant's case. Again, if you will present your evidence and legal arguments in support of the request, and all the arguments must focus on the applicable standards. So Cameron Bowe, if you would state your address and your relationship to the case, I will reaffirm your oath.
My address is 115 Hudson Street in Raleigh, North Carolina, and I'm applicant.
Do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Please go ahead. And if your wife is also going to testify, I will swear her at that time.
Okay, thank you.
Reaffirm her oath, excuse me.
So the overview is that we're requesting a 2.5 foot variance on the 2.5 foot minimum setback for our driveway. As you can see in the photos here, we have an existing gravel driveway that is about half of the length of the intended full driveway, and our intent here is to pave this driveway and extend it into the backyard in order to reach our garage and ADU. Can you go back one slide, Justin, please? So the gravel driveway effectively goes to the back of the house at the moment, and it has been gravel probably since the house was built in 1915. So you can see here where the width between the house and the structure there and the lot line is not adequate for a driveway of reasonable width. And so for us, the hardship results here because the lots are so narrow. This house is one of 5 that was built in a subdivision and platted in and around 1915. And so all the houses here on this side of the street, 2 on either side of us, are almost exactly the same. and have very similar situations to ours. Justin, would you mind going ahead 2 slides? Yeah, so this is an example of one of the 5 houses, and I'll go through a couple of them. So it's very common in this neighborhood, and especially in this street, and even in this original subdivision from 100 years ago, to have driveways that are abut the property line. And Justin, can you move to the next slide? So the one before and this one, 111 and 113 Hudson Street, show an example of that. So this is an example of a concrete driveway that is within inches of the property line. Next slide. This is the house on the other side of ours. The street view angle is a little hard to see, but that driveway is also abuts the property line. And then next slide. And then across the street, houses that were built a little bit later in the 40s also have driveways that abut their property line as well. And then the same as with the next slide, which is 112 Hudson. So these are all of the houses that surround us. So we believe it's within the character of the neighborhood that this variance would not negatively impact that and would be consistent with the rest of the neighborhood and the surrounding houses. Additionally, we believe that it's important, right, to maintain the character, and our goal here is to improve the property. We actually have the only gravel driveway that's left on Hudson Street, and so we like to improve the property and aesthetically and functionally. And we understand that there are several concerns or considerations for the variant or for the UDO requirement that we're asking for a variance for. First of all, that was put in place in, I believe it went into effect a few years ago. I think it's TC 717, and that was adopted in 2018 and went into effect in 2019. We purchased the house with the existing lot and that structure on it in 2015 with the intention of building a garage in the backyard since. Additionally, the three areas that that UDO infill requirement intended to try and solve were, one, to ensure that there was adequate space, right, for people to be able to get out of vehicles and such, and not encroach on the neighbor's property. We try to be very considerate of our neighbors in that way, and understand that we all live in a very tight neighborhood, and so we certainly appreciate that concern as well. The second concern is stormwater management, right, and an intent to retain stormwater runoff within the property and not affect neighboring properties. And so with that, our intention is to construct this driveway with permeable pavers, which would actually potentially capture more than the runoff that would be caused by this driveway. With a change such as this within an infill district like ours, the rainwater runoff potentially, we want to minimize the impact of that. Thanks, Justin. So this is an example of what that would look like with a schematic of how it works. So it actually would capture up to a 1-inch rainfall for an hour and then let it dissipate through the ground as opposed to letting it run off into neighboring properties. Lastly, the third aspect of the setback requirement is intended to also prevent damage to neighboring trees and roots and root systems and such. And so that speaks to, one of the reason we selected to put the driveway on this side of the house as opposed to the opposite side where there's a few more feet, is because there is a very old oak tree on the other side of the house that we are looking to preserve and not damage. And so by putting the driveway here, it allows us to not interfere with any large trees and root systems. And with that, I'll wrap up my remarks. And appreciate the board's support and open to any questions.
Okay, thank you. Board members, any questions for Mr. Bowe? Okay, hearing none. We had no one signed up to speak in support. We do have someone who has signed up to speak in opposition. Ross Ziegler, if you are with us, let me remind you that Any evidence and arguments must focus on the applicable standards. And if you're here, if you would please state your address and your relationship to the case, and I'll reaffirm your oath.
Yeah, I'm here. So I live at 113 Hudson, which is in Raleigh, 27608. It's my eastern border that I share with the 115 residents.
Okay. Do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please go right ahead.
Sure. So I do just want to get a small clarification here. When I first inquired with Eric Hodge regarding this hearing, he invited me to participate to share some of my personal concerns. I know that you just recently stated that I should stick to the facts regarding the standards for application. Is it going to be okay for me to speak towards my concerns in general as well?
Yes, yes, go right ahead, and any concerns we have, we will note.
Okay, great. So let me just get started then, just kind of talking about my personal concerns. And I've divided these up in about 4 different areas. So the first is that, as noted in this plot survey here, I have a fence line that extends roughly about 60 to 70% of my property and encloses my backyard. And so that fence is in kind of a deteriorating state, as I would call it. You know, some of the boards are looking a little out of place, and it's kind of crooked in some areas. And so if I had to guess, I would say that it would be appropriate to replace it within the next few years. And so I've spoken to several fencing contractors about what that replacement might look like, and what are the conditions to have it constructed. And I'm being told that just to dig the posts adjacent to a forthcoming driveway would require as much as 12 inches, potentially more, depending upon the style of fence that I choose and how tall it is. And the reasoning for that distance requirement would be they don't want to disturb the ground surrounding any kind of laid surface, such that it might collapse or cause some sort of structural defect. So it sounds to me that if I were to replace this fence, however long in the future, that I would at a minimum have to pull it back a few inches to accommodate this driveway and ensure that no damage ensued. So that right there is a bit of an inconvenience, and certainly something that I have some concerns about. And yeah, just one of the concerns here that I'm outlaying. Secondly, along that fence line, I have some existing trees that do have roots that have expanded over the years. And after speaking with arborists and doing some reading, my understanding is that these root systems exist roughly 3 inches under the soil. That's the vast majority of where they're located. And then if you were to place a hard surface over top, those roots could be negatively impacted and the tree could suffocate and die over time. So that's, again, something that I would like to avoid. And certainly wouldn't want to have any of my trees negatively impacted. I guess I should also say at this point, with regard to both of those items, that the driveway that's being constructed here is intended to attach to an ADU or a garage. And this ADU is 2 stories tall and has a pretty significant presence in the landscape. So unfortunately, as a result of that structure and some of the sight lines, a lot of the privacy that we used to enjoy in the yard when I first bought the place less than 2 years ago has kind of been eliminated or compromised. So my only real recourse to kind of get some of that back is to either maintain or update my fence, and certainly preserve the trees that I have, potentially also plant more trees. And so it would suggest that there might be some difficulty in doing that should this paved structure come into place. So the third personal concern that I have is with regard to safety. So when you have a typical driveway, right, most of the time you're coming down a road, you can turn into your driveway, then you put the brakes on and you sort of tap your brakes, until you find the stopping point, then you halt your vehicle, put it in park and get out, right? Well, this driveway is, approximately 175 feet in projected length. So you're going to need to accelerate to get to the end of that, which means that you're going to be like in an advanced speed, in comparison to the typical, brake tapping situation. So I don't really like that aspect of this. But in particular, when you remove that setback, you remove the ability for a different terrain to be placed in between the fence line and the driveway. And so if you were to ever be distracted, whatever that might be, checking the radio, who knows, in a typical setback circumstance, you'd get that sort of feedback, while you're driving that, hey, I'm off the road surface now. Whereas in this application, it would appear that the feedback you get is that you slammed into the fence. So, I mean, that just personally to me adds up to a not great situation, coupled with the fact that this is my backyard in an area that I spend a lot of time gardening, weeding, what have you. I certainly wouldn't want personal injury to be a part of this at all. The last thing is runoff. I think Cameron addressed that, spoke toward using some kind of permeable paver solution here, and I think that's really commendable. I love that, and I think that that's probably something that we could do more of citywide and would all benefit. But my full understanding of these technologies is that they still don't perform as well as a grass surface, and so I personally have had issues with drainage on my soil already, and there's been a project that I've been working on for the past 6 months with contractors trying to get this resolved. It's still not resolved, and because of the way that our plots are set, in terms of elevation, where their plot is at a higher elevation than mine, I can only guess that the situation would be worsened, with the installation of any kind of a paved surface. Just a concern. And so I think that really kind of captures like the 4 areas of personal concern that I have. But I also did just kind of want to talk about the standards themselves and how they're being met here with this proposal. And so, just starting from the first one, where it says unnecessary hardship would result from the strict application of the ordinance. And, the basic right up here was that the setback would not allow for the appropriate driveway width. So I guess I just want to say that, like, I have a driveway, and it's of a certain length. And if you look at the plot map that was provided in this proposal, you do see that there is enough space to put a driveway that could hold 2 or 3 vehicles and work just fine. I think that the difference here is that they're attempting to build a 175-foot long driveway, and that's where they're kind of running into problems. Even more interestingly, to me anyway, when I look at that plot map, if you do the quick map of 9.5 feet, which is what the width to which they want to build, plus that 2.5-foot setback, you get 12 feet. And so if you look on the right side of the property, they have 15 feet. So it seems to me that they would have ample space to do the full 175-foot drive if they just did it on the right side of the property instead of the left side. So, I don't know to what legal standards, these kinds of discussions are held, but I mean, when I'm looking at it, it just doesn't seem to me that this first item here would be fulfilled. For item 2, it says that the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Cameron started this presentation kind of discussing that there are lots of properties that have this similar set of circumstances with regard to the size of the lot and where the homes are placed. These homes do have driveways, but they're just not as long as the ones that the Bow family is proposing to build. And so I guess I would just say that, like, this does not seem to be a unique hardship. It seems to be that there is a sort of commonality across many properties on the street. The third one is like the speaking toward that the hardship results from conditions peculiar to the property. Sorry. Hardship did not result from actions taken by the applicant or property owner, right? And so in this case, while I agree that, you know, when the property was constructed and the purchase date, you know, coincide with a time that was prior to the adoption of the rule. Again, it would seem to me if everything that I've said prior to this is valid, that this actually would be a self-created hardship, such that the only reason why they need to extend it that far to begin with is to get it to arrive at the base of this ADU. And then so for item 4, it says the requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice is achieved. And so when I read through the actual document, TC 7 2017, it says, whereas the required setback for vehicular parking surface in an infill context can result in a decrease in unintended trespass by vehicles, vehicle doors, persons exiting vehicles, decreased damages to neighboring properties, landscaping, and appurtenances, as well as decreased potential for stormwater runoff issues onto an adjacent property in the city's established neighborhoods. You know, when I read that, and then again going back over some of the things that I've discussed, it really doesn't seem like that's being captured or you know, being held in the spirit of this at all. It would seem like quite the contrary. So yeah, I guess I personally take issue with kind of all 4 of these items here, and then also have my personal concerns, and so that's why I'm speaking in opposition.
Okay, thank you, Mr. Ziegler. Appreciate that. Board members, do you have any questions for Mr. Ziegler? Okay, Mr. Bowe, you have an opportunity to cross-examine or ask questions of Mr. Ziegler if you wish to do so.
No, so I am at first we're disappointed, I guess, to hear these concerns for the first time here. But I think at this time we would like to defer this to the April meeting if it's possible to do that at this time.
Certainly, it's your privilege to do so. So at the request of the applicant, they want to hold this case till our April 11th meeting, at which time we would represent it. Ms. Hill, anything I need to do differently to simply accept that?
No, not since we're remote. If the applicants requested it to be continued, you can just state it's being continued to a date certain, which you've stated was April 11th.
Excellent. Thank you. In that case, Mr. Bowe, we will continue this case till our April 11th meeting. And thank you for your presentation, Mr. Ziegler. Thank you for your time as well. And with that, we will move along to our next item of business. This is 4911 Waters Edge Drive, Passovitz Holdings LLC property owner. This is a variance, VOA 0003-2022. Colin McGrath is representing the applicant today. I would say again that variances require a 4/5 vote, and we only have 4 voters today. So Mr. McGrath, if you or your applicant have any desire to hold this till our subsequent meeting, or if you're willing to continue today, it is your choice. I just wanted to bring that to your attention before we got started.
Thank you, Mr. Chair. Colin McGrath. We're happy to proceed today. Thank you.
Okay, thank you. Mr. Booker, I will ask you again to lead us with a staff presentation.
All right, thank you. So this case BOA 0003-2022 is for 4911 Waters Edge Drive. Pacewicks Holding LLC property owner is requesting a 51 and 7-inch variance, 51 foot, excuse me, and 7-inch variance to Special Highway Overlay District, or SHOD, protective yard landscaping requirements as set forth in UDO section 5.3.1.H.2 to construct 1,337 square feet of building addition within the SHOD overlay, and a 49-foot and 6-inch variance to shod protective yard landscaping requirements as set forth in UDO section 531H2 to construct a 1,678 square feet of exterior decks, ramps, and landscaping walls within the Tod Overlay area. This is in association with improvements to an existing building on a 0.72 acre property zoned OX3 and located within the Special Residential Parking Lane Overlay District and Special Highway Overlay District 1, located at 4911 Waters Edge Drive. Shown here is just the zoning map and kind of a context. You can see the site is directly north of I-440. And just to orient ourselves as I walk through the rest of the presentation, here's the property shown in red, and then in yellow is the area that we'll be taking a look at in the next slides. So I'm going to break down how the Tod Overlay changed over time, just to give ourselves a good picture of how we got here. First, here you can see the original property line at the bottom there in dark black. This is prior to the NC 440 widening, which moved the property line. So per Tod 1 requirements, any portion of a lot a major access corridor like I-440 requires this 50-foot landscaped protective yard. So due to the widening, the property line moved, and shown here is the Tod protective yard according to the new property line configuration, the post widening. And then lastly, there was an NCDOT placement of a public utility easements over a portion of that area. So that kind of bumped out the Tod landscaping requirement further out. So as you can see, the majority of the existing two-story building is now located within that Tod yard. So with that, I'll hand it over to the applicant, and I'm happy to answer any questions the board may have.
Okay, thank you. Board members, questions for Mr. Booker? Hearing none. Okay, Mr. McGrath, welcome. I'll let you proceed with your presentation, please.
Thank you and good afternoon, Chairman Swink, members of the board. Colin McGrath with Pointer Sproul, 301 Fayetteville Street, Suite 1900. Here today on behalf of Pasevich Holdings, the applicant and property owner, in connection with its request for a variance to expand and upfit this nearly 50-year-old office building at 4911 Waters Edge Drive. Jerry Pasevich, who is the manager of the applicant and property owner, as well as Matthew Konar, the project architect, are both joining us today. To streamline things a little bit, we've submitted an affidavit from Mr. Pasevich, though he is available for any questions, either from the board or staff. Really appreciate Justin's thorough presentation that kind of walked through how we got to the request in front of the board. So we'll try not to duplicate efforts. Next slide, please. So as Justin mentioned, 4911 Waters Edge Drive, currently zoned OX3 conditional use with both the Tod 1 and special residential parking overlays. This is West Raleigh, Jones Franklin Road, and the Beltline, just to the northeast of that interchange. The property is used for office use and is surrounded by predominantly office and medical buildings. Next slide, please. So from this 2020 aerial, we can put a little more color on some of the problems that led us to the variance request. But from the aerial, you can see that the lot is a flag lot. Its frontage on Waters Edge Drive is really no wider than a driveway and widens to the south with enough room for some parking as we come down. But most of the buildable area is concentrated in the southern portion of the parcel, which is bounded by the Beltline. As I mentioned, the office building here was constructed in 1974. It's about 5,200 square feet. There are 2 tenants currently in this building, one of which is Triangle Strings. You see the logo at the bottom of the slide, which is Mr. Pasevich's stringed instrument repair and restoration shop. There's also a small dental practice on the first floor. But as you can see, this 2020 aerial, the southern portion of the parcel was at this time heavily wooded, consistent with SHOD requirements. And in fact, in 2020 or earlier, you could be forgiven if you're driving down the Beltline and don't even know this building is here. Next slide, please. So this is the 2021 IMAPS aerial. And you can see just from this aerial kind of what has happened in this area. As Justin mentioned, in 2017, the DOT announced plans to widen Interstate 440 from 4 to 6 lanes from roughly Wade Avenue through to Cary. That involved a fairly substantial taking of land on this northern side of the Beltline, including of the property. Next slide, please. And my apologies, I'm trying to move a little quicker since Justin covered a lot of this, but this slide shows the existing building with the old property line. It shows the former SHOD requirements. Again, a 1974 building. SHOD was subsequently overlaid on the property, which made the building non-conforming. When Pasevich Holdings purchased the property back in 2015, it did so with the plan to renovate, update, and expand the building. But given that prior SHOD nonconformity, a lot of effort was taken in 2016 and early 2017 to come up with a plan that would allow that expansion, but not increase the degree of nonconformity. Next slide, please. This is the original plan that Mr. Pasevich came up with back in 2016. It was actually submitted and approved in 2017 with a site plan in March of 2017. You can see that the initial plan was to essentially follow the SHOD line through the property. An addition on the southern side of the building would have a bit of an irregular shape, but that was important to Mr. Pasevich at the time to not only avoid any further intrusion into the SHOD, but also to protect all of that former tree cover. Next slide, please. And by contrast, this is where we are today. So in 2017, that approved site plan was never constructed for a couple of reasons, one of which being the announced takings plan. This slide shows the extent of that taking with the new property line. You can see the area taken at the bottom of this drawing that was taken in fee simple. The taking also involved the dark gray utility easement. The utility easement was actually drawn, it had to cut around the building just to give a little bit of room there. Currently, the property is about 22 feet from the new property line, and it varies, but it's roughly 4 to 6 feet from the utility easement. Next slide, please. Just to visualize the impact of that taking, including the easement on the property. The top picture, of course, is the before. You see the densely wooded, you can barely see the Beltline right of way versus the after DOT came in and clear cut the property not long after it actually made the taking. Next slide, please. Here's the building from a different angle, actually from the Beltline right of way. What you would have seen a couple years ago, that dense tree cover is now essentially a distinctly 1970s building perched above the interstate. Next slide, please. And here's that perch from the inside of the building. Now, we walked through these pictures because, you know, not only are we prohibited from planting within the, obviously the land that was actually taken and the utility easement, but these show how close the building actually is to the road improvements. Next slide, please. So going back to the post-taking existing structure drawing, you can see almost the entire building is now within the shod yard, when formerly it was just a very small portion. The taking of the utility easement leaves us in a situation where even if we wanted to, we cannot put you know, sufficient natural landscaping between the building and that utility easement to accomplish the purposes of the shod overlay. So while the taking did impact our ability to expand the building and not increase the degree of nonconformity, it didn't impact the need to update and expand the building. So we did have to go back to the drawing board on how to preserve what trees are still on the site, as well as accomplish the property owner's goals of updating and upfitting the building. And so to walk through the specific plans, I'll turn it over to Matthew Konar.
Okay, Mr. Konar, Mr. Konar, if you would please state your name and your address and your relationship to the case, and I'll reaffirm your oath.
Sure. Matthew Konar, 611 West Club Boulevard, Durham, North Carolina. And I was architect of record of the original project and assisting Triangle Strings and Jerry Pasowitz with the proposed new design of the building and the addition.
Okay, thank you. Do you swear or affirm that the testimony you'll provide will be the truth, whole truth, and nothing but the truth?
Yes, I do.
Thank you. Please go ahead.
Okay, great. Thank you. So to follow up the conversation so far, we did do the project before, and obviously we took a hold on the project in order for the DOT and for these lines, these new property lines, new shots, and everything to be adjusted. As you guys can see, there was a significant movement of the shod lines, and the existing building is significantly, if not, let's say about 85% now within the shod, being an existing condition based on the DOT. You can also see in the darker gray that the movement of these property lines in the shod was so significant that even the utility easement has to do a little dogleg, a little cutout, due to the existing building. So we wanted to point out the severity of the impact that the DOT did on moving of these lines. So if we go to the next slide, please. So what we've tried to do here, and I apologize, not sure why there's a white square in the middle, but what we have done now is reorganize preliminary in a schematic design fashion. The addition to the building to be more respectful, one, to the building, be much more rectilinear, but also respect the building and the situation as it is. We will not encroach upon the utility easement any further than the existing building does. Obviously, once again, we are not asking for any kind of cutbacks or anything in the utility easement. And of course, as you can see, there's really no feasible way to add to this building without the variance and without the ability to be within the shot. Next slide, please. And the last thing we wanted to mention is that there's an old existing tree that we're going to do everything we can to preserve. You guys can see the amount of clear cutting that was done by the DOT. You know, the purpose of a shot is really to provide a tree buffer, and that buffer is pretty much nullified because of the location of the existing conditions and where the shot has been replaced. So this one existing tree, it's super important for us, but it's also super important for Jerry. During the design process, one of the coolest things we learned is that they actually, everybody who repairs violins, when they do their varnish, they actually look outside and look at nature, and a green especially. Green is actually a natural color that resets your eyes, so that when they match varnish and do some of the very, very specific craft that they do, they actually need the greenery. So it's a very significant impact to Jerry and very important for us to keep this tree. So just wanted to go over some of the impacts and how we're trying to be respectful to the new conditions that we have and respectful to being within the SHOD based on the conditions that the DOT has placed on us now. So thank you for your time, and I turn that back over to Colin, please.
Okay, thank you.
Thank you, Connor. So Mr. Chair, members of the board, I think what I hope is clear is that the variance request is intended to solve a problem that we would much rather not have to solve. Obviously, Jerry and the team put in a lot of effort back in 2016 and 2017 to come up with a way to improve the structure in a way that works for Jerry and his business, and in a way that also honors the then existing SHOD. Unfortunately, the taking, which we all understand was necessary to improve the Beltline, but the taking rendered even that modest expansion impossible without increase into the SHOD from the building footprint. So if we can go to the next slide, I just want to quickly walk through the variance standards. First, that unnecessary hardship result from strict application. As we've discussed a little bit and as outlined in Jerry's affidavit, strict application of the ordinance would essentially prohibit any meaningful expansion of the existing structure. Based on the relatively small size of the office building, about 5,200 current square feet, nearly any reasonable addition will exceed the 25% threshold that would allow us to go the special use permit route. Additionally, following the taking, as we recall from that last slide, there's really insufficient area on the property to expand any portion of the building and not increase the degree of SHOD nonconformity. Again, that was the purpose of the unique design of the 2016 plans that Connor and his team came up with. But given the new property line, the new PUE, almost the entire building is now within the protected yard. Only that northernmost portion of the building is outside the SHOD, and there's simply insufficient area in that portion of the parcel to expand the building. We would suggest that the hardship here is unnecessary, as that wooded buffer between the interstate and the existing building has already been removed, leaving us as the property owner really insufficient area on the parcel to reestablish that buffer to any meaningful degree. So we would suggest that that's certainly an unnecessary hardship. The hardship results from conditions peculiar to the property. As we walk through, the property is a flag lot. All of the buildable area is in that southern portion, which is exactly the portion that was significantly impacted by the taking and the subsequent relocation of the SHOD boundary. This significantly increases the degree of hardship. As we've discussed, there's really insufficient non-SHOD area on the parcel for even a modest expansion. I'd also note that if we assume for a second that the existing structure were not there and we were starting fresh, there's almost no way that any structure could be placed on this property without a SHOD variance. So we'd certainly think that even though a number of other properties had land taken, the size and the shape of this is unique. Of course, this is not a result of any action from the property owner. We certainly cannot control the DOT, either the extent of the taking or the degree of the clear cutting. And in fact, prior to the taking, we did everything in our power, including getting an approved site plan, to expand and improve this structure in a way that didn't increase the impact on the SHOD. The request here is also consistent with the spirit, purpose, and intent of the ordinance. As the board's aware, the SHOD's primary intent, as Connor discussed a little bit, is to maintain those natural buffers along major routes to separate uses from these major thoroughfares. and to also provide a pretty consistent natural view from the right of way. Unfortunately, based on the degree of taking and the DOT clear cutting, this intent has been entirely frustrated, again, through no fault and indeed over the objection of the property owner. The existing building and property simply cannot meet these SHOD requirements or any other reasonable visual screening given the location of the PUE and the clear cutting that's already happened. So we'd suggested that the variance would allow this reasonable expansion of the older office building. It's been redesigned, as you heard from Konar, in a way that will preserve what mature trees that we can. And at least at the end of the day, if this is a building that no matter what is going to be highly visible from the right of way, that it at least be an updated, aesthetically pleasing view. I'll also note that we've not heard from any neighbors who oppose the request. It's my understanding that nobody has signed up to speak in opposition. We're available to answer any questions, but we'd ask that our presentation, our application materials, and the affidavit of Mr. Pasevich be included in the record and the board grant the requested variance.
Great. Thank you, Mr. McGrath. Appreciate that. Board members, any questions for Mr. McGrath or for Mr. Konar? No? Okay. Hearing nothing else, then let's close the evidentiary hearing and move to our board deliberations. I'll just say quickly that very challenging circumstances you're dealing with there with the loss of all that tree buffer. It's got to be fairly dramatic on site. I certainly applaud you saving the tree, attempting to save the tree, and then hearing the story as to why made it even more interesting. So good luck with that. Hopefully it survives all this turmoil. But I'll entertain a motion.
I move we approve.
Thank you, Ms. Rudisill. We have a motion to approve. We have a second. I'll offer a second. We have a motion to approve and a second. Any further discussion? Then let's move to a roll call vote, please. And unmute yourself, please.
Mr. Swink,
Approve?
Ms. Rudisill,
Approve.
Mr. Kenny,
Approve.
Mr. Butler.
Approve.
You have 4 affirmative votes to approve.
Thank you very much. Let's move to our fourth evidentiary hearing item and new business.
We got it.
This is 200 Michael J. Smith Lane. CASA is the property owner. The variance, and this is a variance, BOA 0004-2022. And Mr. Todd, let me point out, as I have in each of the other cases, requires a 4/5 vote to approve a variance. We only have 4 voting members today. So if you have the choice of presenting your case today, or if there's some concerns about wanting to wait until we have more members present, you may choose to do so. So, Mr. Todd, your preference?
Hear me? We would like to move ahead today. Thank you.
Okay, very good. In that case, Mr. Booker, if you'll get us started, please, with your staff presentation.
Thank you. So yes, this is case BOA 0004-2022, 200 Michael J. Smith Lane. CASA, the property owner, requests a variance from Unified Development Ordinance sections 3.4.7.c.2 and 5.5.1.d.1.b, which requires a minimum of 50% building width in the primary build to, and this is to allow 32% building width in the primary build to, in association with the construction of apartments on a 4.26 acre property zoned OX5 with a parking limited frontage conditional use and located within the transit overlay district at 200 Michael J. Smith Lane. Shown here is just an aerial of the site. You can see it is south of Carl Sandburg Court and just east of Sunnybrook Road. And then shown here is the proposed site plan. You can see the building is located at the corner of Carl Sandburg Court and Michael J. Smith Lane. It's highlighted in red there. And then just a closer up image of the site. You can see to the south there is a wet pond, a stormwater control device there. And with that, I can hand it over to the applicant, or if there's any questions, I'd be happy to answer them.
Great, thank you. Board members, any questions? Mr. Booker? Okay, then let's move to Mr. Todd. You may proceed with your presentation, please.
Thank you, Mr. Swink. My name is James Todd. I'm with Smith Anderson here representing CASA today. I'm joined by Jess Brandis, CASA's Senior Director of Real Estate Development, and Jennifer Wagner with Prospect Landscape Architecture, who was the landscape architect for this project. And thank you, Mr. Booker, for his presentation. As he described, and as many of you are probably familiar with CASA, they are a nonprofit dedicated to providing affordable and supportive housing. They're seeking a variance today for a portion of the urban limited build-to requirement along roughly 90 feet of the Michael J. Smith frontage to accommodate a multi-tenant building. And before we go into the specifics of the variance request, I'd like to give Jess Brandis a few minutes just to discuss the project and explain why they've chosen to locate it here and some of the benefits that we expect out of this site.
Mr. Brandis, if you would, for the record, please state your address and again, your relationship to the case, and I'll reaffirm your oath.
Can you hear me?
I apologize, Ms. Brandis, my apologies. Yes,
No problem.
go right ahead.
Yes, I'm Jess Brandis, Senior Director of Real Estate Development for CASA. CASA's address is 624 West Jones Street, Raleigh, NC 273.
Do you swear or affirm that the testimony you'll provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please go ahead.
Thank you, board. Thank you, James. Just wanted to briefly introduce CASA and tell you a little bit about this project. CASA is currently celebrating our 30th year of developing, owning, and managing affordable housing for those in our community who need it most. Our tenants are people with disabilities, in particular, people who have experienced homelessness. At CASA, we create safe, permanent homes for our neighbors in need, and then we support our tenants through making connections to supportive services and by charging an affordable rent. This project, Kings Ridge, will create 100 homes for families and individuals who are currently experiencing homelessness in our community. The future residents will pay just 30% of their income for rent, and we will have access for those tenants for a variety of services and supports on site at the property, including case management, a nurse, a fitness center, 24/7 staff, and a variety of programs and classes. We're particularly interested and excited about this site. It has proximity right across the street to transit service that is the most high frequency transit city offers. We're excited that it is in the Transit Overlay District to support those uses. We know we'll have a lot of transit users because of the tenants we'll be serving. And it's adjacent to other CASA properties, so it will allow our staff to better serve multiple properties in that area.
Okay, thank you. Mr. Todd, anything else?
Yes, if we could go to the third slide, please. So as Jess said, we're excited about this project and the site. For some context, we didn't provide an image of it, but if you zoomed out, this is in the east of Raleigh. It is southeast of the large Wake Med campus on New Bern Avenue. It's close to the intersection of 440 and Highway 87. It's near a variety of services and transportation resources for the future residents. This property is zoned office mixed use 5, parking limited frontage, and it has the Transit Overlay District, or the TOD, which we'll speak a little bit more about in a moment. But when there is a TOD overlay with parking limited frontage, the property is required to meet the urban limited frontage requirements. And in this case, that requires a build to of 0 feet to 20 feet along 50% of the primary road frontages. For this site, both Michael J. Smith and Carl Sandburg Court are considered primary frontages. And the numbers that you see in the right of the graphic on the screen show the required build-to widths and what we're able to provide given the site constraints. So there's no issue with Carl Sandburg Court, but as you see on the graphic, the yellow area is the required build-to, and it extends all the way down to the very southeastern portion of the property. Given the narrowness of the site towards the south, as well as the topography of the site and the unusually long frontage along Michael J. Smith, the building runs into the problem of being forced to extend under the code an unusually far distance down Michael J. Smith. There's about a 722-foot frontage along that area, portion of the frontage that is proposed to be used for driveway access to the property, as well as the stormwater pond in the southeast portion of the site. Extending the building that far creates two primary problems. One is that the building itself becomes unwieldy on the site. The second is that it would require the relocation of the stormwater pond. A situation that's made even worse because the Neuse River buffer runs along the southwestern portion of the property. You can see the outline along the dotted line there that further kind of cramps development down in the southwest portion. The property has several unique factors that lead to the request. I've mentioned the topography, with the land sloping downward from north to southwest, the extremely long frontage along Michael J. Smith, and also that this is subject to the TOD Transit Overlay District. I believe at this point it's one of only a handful of sites in the city that is subject to the TOD. I'm familiar with, I think, 3 of them. There might be a couple more that we didn't note on the plan, but it's the only site in this area subject to the TOD. CASA has done what it can to design around these constraints, but the dimensions and the topography of the lot have largely dictated the building placement and have resulted in this obstacle. If we can move to slide 4, please. So most of this are issues that we've covered. And we are requesting an adjustment in the build-to requirement from the 325 feet along Michael J. Smith to 235 feet to allow the location of the building as it's proposed on the site plan today, as well as the driveway and the stormwater pond in its location. Strict compliance with this TOD build-to would require CASA to extend the building much too far down the frontage, relocation of the stormwater pond, which would be prohibitively expensive, as well as require relocation to an area that is currently proposed as an open space with a picnic pavilion, a walking trail, and trees, and potentially losing the driveway access and requiring some sort of unusual workaround in that case. So it's, as laid out, the site plan does what it can to take into account the unique condition of the lot. But the build-to, because of that, like I said, that 722-foot frontage on Michael J. Smith poses a real problem for the site plan. If we can move to slide 5, please. Thank you. So this shows the TOD overlay. And as I said, it's the only site with this zoning in the area. But it also shows, I think, one of the purposes of the urban limited frontage and why I think this variance is a good fit for this site. So the urban limited frontage is designed to produce a uniform street frontage. It keeps buildings close to the sidewalks or the roads, creates a uniform frontage along several blocks. This site, the property runs for the entire block between Carl Sandburg and Sungate Boulevard. There is no parallel road that extends to the north or to the south. So we're not proposing what I like to think of as a missing tooth, where you'll have a drawback in the build-to and then an adjacent building that will pick the frontage back up. There just aren't going to be developments along roads that run parallel to Michael J. Smith, or that continue Michael J. Smith Lane. The urban limited is intended to provide a consistent streetscape, but in this case, Michael J. Smith sort of is the only street. So we don't think a variance is inconsistent with either the area or the intent of the ordinance. This is a situation with a site-specific zoning requirement that is unique to the property, and also one where I think the purpose of the ordinance is not particularly apt, because, as we said, there is no extending road. At the same time, you have a situation where the topography of the site has dictated the proposed layout. The applicant, is dealing with the lot as they found it, but didn't create the problem themselves. And if forced to comply with the TOD and urban limited frontage requirements, is going to face a really significant hardship in their plan. This is a really exciting site. This is an exciting project that is, frankly, good for the city and good for our residents, and potentially could be frustrated here by the application of this unique zoning district. We think the UDO's frontage requirement is consistent with the proposed design, and we request both that our presentation be placed into the record, and also that this board would grant variance today to reduce the build to requirement for that small portion of Michael J. Smith Lane.
Okay, thank you, Mr. Todd. Board members, do you have any questions for Mr. Todd or Ms. Brandeis? Hearing none. Mr. Booker, anything else from you?
I do.
Oh, pardon me. Go ahead, Mr. Kenny.
Sorry, I was muted. This is Steve Kenny. Can y'all pull up the site plan again, please? Okay, so what is going on in this sort of white triangle piece in the southwest of the site?
This
Yeah,
is Jennifer Wagner. If I could, I'd be happy to speak to the
Please.
question.
Okay, Ms. Wagner, before doing so, and welcome, let me ask you to state your name and your address and your relationship to the case for the record, and then I'll reaffirm your oath.
Sure. It's Jennifer Wagner with Prospect Landscape Architecture. I am the landscape architect on the project.
And your address?
227 Glasscock Street in Raleigh.
Okay, do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Thank you. Please go right ahead then.
Great, thank you. So I'll just speak to this, and I apologize that the property line is not very visible in this graphic, so it makes it a little bit confusing. The property line is essentially the center line of the creek that is, if you can see the sort of dashed line that runs right along the backside of the pond and then up toward the northwest of the property, kind of where the property line crooks in a little bit, if that makes sense. There's that dashed line. That is the riparian buffer, which is something that I wanted to point out is another constraint, is that we have this riparian buffer, and that is primary TCA. So we are required to keep that area, which is why the stormwater pond is kind of pushed over toward the road a little bit, and the property really angles up toward the northwest. So in answer to your question, were you talking about that white area in that area, or the white area?
Yeah, kind of what I'm
south?
getting at is you've been saying that we've got to have the stormwater pond here. And I'm looking at a lot of other open space and wondering why it's not there.
Yeah.
And the other piece I'm wondering is, and I'm fully conscious of how much it costs to do this stuff, but people put stormwater detention underground all the time. So I'm having a bit of a trouble understanding why that's a hardship when y'all could do it here. Thanks.
So sure. So the majority of, I think the area you're talking about is not our property.
It's your property. I'm talking about, I wish y'all had a little better site plan here, but
Yeah.
the building's kind of an L. There you go.
There we
That's a
go.
good one.
Yeah.
Yeah, I'm talking
that's
about
easy.
that triangle to the southwest of these buildings. And what is that?
Right, okay, so that will remain forested, that's currently forested, and that's a walking trail in that area.
And y'all
The
can't
store,
put storm water there.
we would be piping uphill if we did so, but
Okay.
that is an area that could be put. It's we have the stormwater pond at the lowest portion of the site.
Mm-hmm. Okay.
Anything else, Mr. Kenny?
No.
Okay, thank you. Good questions. Anyone else?
Mr. Swink, if I could,
Please.
one more thing I wanted to add regarding the riparian buffer. This is part of the reason that the block is rather large. We are exempt from block perimeter because of the riparian buffer, and also because of code section 8.3.2.A.1.B.4, which is related to if a road were to go through the site, it would take more than 15% of the site.
Okay, thank you for that clarification.
Sure.
Any other questions? Mr. Todd, any last words from you?
No, just that we appreciate the board's consideration, and look forward to your decision.
Okay, well, no one signed up to speak either in support or in opposition to this. So hearing nothing further from the board or staff, we'll close the evidentiary hearing and we can move to our board deliberations or a motion.
I make a motion, we approve.
Thank you, Ms. Rudisill. We have a motion to approve. May I have a second?
I'll second.
Mr.
Morgan.
Sorry, thank you. Thank you. We have a motion to approve and a second. Is there further discussion? This is a variance. Let's move to a roll call vote, please.
Mr. Swink,
Approve?
Ms. Rudisill,
Approve.
Mr. Kenny,
Approve.
Mr. Butler.
Approve.
You have 4 affirmative votes for approval.
Great, thank you very much. Okay, that takes care of our business for the day. Let's move on to approval of the minutes from our February 14th, 2022 meeting. They were all made available to you. Any additions or corrections? I have a motion to approve. Mr. Butler?
So approved.
Thank you. I have a second. Mr. Kenny?
Oh, second.
Thank you. We have a motion to approve in a second. We'll need a roll call vote for these two, Ms. Smith.
Okay, Mr. Swink,
Approve?
Ms. Rudisill,
Approve.
Mr. Kenny,
Approve.
Mr. Butler.
Approve.
You
Great,
have 4
thank-
affirmative votes to approve.
Thank you very much. Catherine, anything from you today?
Just a quick reminder, I think you all know from the emails about scheduling this meeting that starting in April, you guys will be back in person, all city boards and commissions. So I believe everybody's been notified of that, but just wanted to mention that and some of the QJ processes that we've been doing, you know, the signing up beforehand and the doing the oath forms, all of that, some of those QJ processes will be able to drop once we go in person. The other thing is, maybe I'm behind on this, but Keegan, where are we on scheduling the retreat? I think that we had a date, but then we realized that the date was in March, and then with it being in person, I think in person would be preferable if possible for the retreat. And so I think we were looking at some April dates as well.
Yeah, that's right. Thanks, Catherine. So I'd sent out a updated survey for a week in April. I know that doesn't work for everyone. So we will just need to look at those survey results and see who is able to attend. The reason that week was selected is because of staff's commitments to the council and the appearance commission, and also the planning commission as well. So it's difficult to find availability. But I think Catherine and I just need to review the responses and see if we have a date that works for the majority of folks. And if not, we may need to start looking at other weeks.
Okay, so to be continued on that. We'll get back to you as soon as Keegan and I can talk.
Okay, great. Well, thank you. A couple of things from me before we wrap. First, Gail Smith, good to see you. Thank you for stepping in for us. We appreciate that. Secondly, Justin, I apologize for kicking you out of the meeting when Travis announced his presence to me. All I heard him say was Justin, and my mind immediately went to you, and which was because Catherine had just told me that you were stepping in for Eric. So you were on my mind, and I thought, well, that's weird. Why didn't she tell me that he wasn't going to be here? So I was rapidly trying to make notes. Anyway, I apologize for that, but thank you for allowing me to muddle my way through today. It was sort of a strange case for me. But with that, thank you all for making yourselves available. This is the first time we've been down to 4 actual voters. So I appreciate that y'all were able to be here. And I look forward to seeing you all in person next month. Anybody have anything else they want to offer? In that case, oh, well, you're welcome. You're welcome. It's always good to be with all of you. So y'all take care, stay well, and I look forward to seeing you in person next month. And let me know if you need anything.
Thanks very much.
Take care.
Bye-bye.